hereby set aside. Sheet is ready. Okay. I must say, at the cost of repetition, that the judicial decision which laid down the principle in Ved Prakash versus the state of Haryana Supra still holds good. The court must take into consideration the status, the position of members of family, and other social factors of background of the convict before sentencing him. The learned trial court has to record that he considers all the above factors before passing the sentence. I'm not saying that after considering such factors as stated above, the court cannot refuse to release the offender on probation of Offenders Act. What I want to say that the judgment must show that the learned court has considered the relevant factors and has held that there are certain reasons for which the court is not considering the convict to be released on probation under the provisions of under Section 4 of the Probation of Offenders Act. In view of the above, though the conviction of the petitioner is hereby upheld, but the sentence upon the convict being found unsatisfactorily imposed upon him is hereby set aside. The learned Chief Judicial Magistrate Maya Bandar is requested to rehear the convict once again regarding quantum of sentence and also on the provisions of Probation of Offenders Act, and to pass a fresh order of sentence after taking into consideration all the relevant factors as mentioned herein above. Accordingly, the present criminal revisional application is allowed in part on contest. The conviction order of the petitioner, namely Pratap Hamron, in connection with GR case number 26 of 2014 of the learned Chief Judicial Magistrate Maya Bandar, is hereby affirmed. However, the order of sentence is hereby set aside with a direction upon the learned Chief Judicial Magistrate Maya Bandar to hear the petitioner convict afresh on the point of sentence and also on the provisions of Probation of Offenders Act 1958, and to pass an order of sentence upon the convict within 3 months from the date, and the petitioner convict is directed to appear before the learned trial court as and when he is called upon by the learned court. A copy of these orders will be sent back to the learned Chief Judicial Magistrate Maya Bandar immediately. Why you are writing why Code of Criminal Procedure? The CRPC, Criminal Procedure Code. Every time you should write it. Not Code of Criminal Procedure. That may be a Code of Civil Procedure Code, but Criminal Procedure Code. At least in my order. Have considered the materials on record. On the basis of complaint of respondent number 2, CR case number 44 of 2023 has been initiated against the present petitioner along with other accused persons. On 15/3/2023, the learned Chief Judicial Magistrate Port Blair had taken cognizance. Admittedly, the petitioner, Mr. B.M. Kumar, being the accused number 10 in the complaint case, is a public servant. By virtue of Section 197 Criminal Procedure Code, it is incumbent upon the concerned court taking cognizance against such public servant is to record that cognizance is taken after obtaining sanction against such public servant. From the order dated 15/3/2023, I do not find that cognizance against Mr. B.M. Kumar has been taken after obtaining sanction from the appropriate government. It is true that when a public servant exceeded his jurisdiction in discharge of his official duties and when his actions are not covered within the scope of his official duties, no sanction under Section 197 of Criminal Procedure Code may be required. But the learned court has to record the reasons as to why such sanction is not necessary before cognizance is taken by him. He has to specify the grounds as to why provisions of Section 197 of the code in respect of such public servant are not applicable. In other words, the court can take cognizance against public servant without obtaining sanction, but before doing so, he has to record that the alleged action do not come under the coverage of Section 197 of the code. In this case, it appears that no efforts were taken by the learned Chief Judicial Magistrate Port Blair in taking cognizance against Mr. B.M. Kumar, who is an Assistant Sub-Inspector of Police, to disclose that the alleged action of Mr. B.M. Kumar were not covered under the scope of official duties, and therefore he was taking cognizance against him. As a said factor was not taken care of by the learned Chief Judicial Magistrate, I find that the cognizance taken against Mr. B.M. Kumar, being the petitioner herein, is bad in law, and therefore the complaint case, being CR number 44 of 2023 against the petitioner Mr. B.M. Kumar only, is hereby quashed. The order dated 15/3/2023 is bad in law to the extent as indicated above. Revisional application is allowed on contest, no cost. Service is not complete. The learned counsel for the applicant has submitted that service is not complete, and he has prayed for placing the matter before the next available circuit. Stop. List the matter accordingly. Sorry. Why? When you have filed this case, what is the case about? Maintenance, your husband. So you are not happy with the quantum of maintenance. What is the amount? 10,000. Are you sure? He did not go through the brief, your senior's brief. $10,000 you have correctly mentioned. No. Yes, 10,000. From your memory you have. What is your name? Why this order is bad? Why this order is bad? You want enhancement?
Yes, sir.
How much?
No, my actually the respondent is not appeared before this on.
Huh? Respondent did not appear.
That's what we have filed this writ in this.
The learned counsel for the petitioner has submitted that service upon the respondent is incomplete. And as such, he has prayed for similar. Next.
We practice, my lord.
It is tomorrow, yesterday's.
Yesterday, ma'am.
Yes.
The brief fact is that, my lord, this petitioner and the respondent had a love affair for a period of 3 years. Subsequently, on 3rd of August 2016, they got married, ma'am.
So love affairs culminated into marriage.
Culminated into marriage.
It's very natural.
Yes. So, my lord, thereafter, on 1st of September 2016, sorry, my lord, on 29th of
Marriage was taken place when?
on 3rd of August 2016, my lord.
Hmm.
A child was born on 29th of August 2017, my lord. 5th of January 2024, both were started residing separately.
Okay.
Thereafter, my lord, this case was filed, my lord, for divorce by the husband.
Yes.
When the husband filed the case, first time the appearance date was given in the month of June 2024.
So you are appearing for the husband or
Wife.
wife?
Wife.
Okay.
So,
Yeah.
my lord, June,
First
first date for appearance of the wife was June 2024.
you are the wife.
Yes, I am the wife.
Husband
Appearance
files.
before the trial court.
And husband files on which ground?
Cruelty, only cruelty.
Cruelty means physical cruelty or desertion or
No, only cruelty. He said that we always
mental cruelty.
That physical, there is no scope, my lord.
There is
So whatever may be, my lord, so they have filed it, my lord. We filed our we have entered our appearance in the month of June 2024. We did not file written statement before the trial court.
My lord, I am for the petitioner, my lord. Okay. My lord, I am for the petition on item number 7.
Who is for, who is for
Well, I
the,
am for the, yes, sir, ma'am, this is the first motion, my lord. This is the first motion.
hey,
First day.
reduce the volume.
My lord, it is the first day.
Oh.
Motion first day. Motion first day.
Oh, first date. Have you served?
No, my lord, after direction, my lord, I will serve.
The learned counsel for the petitioner is present and he has submitted that he may be what I have said. Present, stop. Present, stop. Admit the civil divisional application. So what is the case, Mr. Kaur?
Mr. Transfer petition, my lord. It's a transfer petition. Wife filed this petition, my lord, under section 125 at Port Blair, but she is residing at Calcutta. She is residing at Calcutta. She is working at Calcutta. I am working also at Calcutta.
Admit the divisional application. The is directed to serve this upon the hearing. Stop.
And my lord, in the meantime, stay, my lord.
What stay?
My lord, stay the proceedings, my lord. Otherwise, my lord, is the
No, what is the proceeding? I asked you to submit about
125 of the Code of Criminal Procedure. That proceeding was going on.
what?
I want to contest with this case, my lord, but she filed this case before the Port Blair, though she is residing at Calcutta.
Your voice is not clear, sir. Your
Voice is not clear, my lord.
yes.
My lord, I am saying, my lord, that she is residing at Calcutta, though she, my lord, filed this case before the Port Blair. My lord, that is why, my lord, I am paying for, my lord, transfer plus this case. And
Where?
from Calcutta Family Court, from Port Blair to Calcutta Family Court.
Yes.
Calcutta Family Court. Yes, my lord. I have written everything. I have written, my lord.
But
And actually, she is working lady, my lord. She is working lady. She is working at, my lord, Calcutta. Only to harass myself, she filed this petition before the Port Blair. Nothing more, nothing else.
no. Why this case has been filed here?
My lord, here, my lord, is as because, my lord, the case is filed before the Port Blair, my lord, magisterial court. That is why this case is filed here.
Yeah. The address is given that Andaman district and
My lord, case is filed here. That is why, my lord, I want transfer. Otherwise, why I will come?
you are appearing for the
Husband. I am for the husband.
so husband is transfer.
Yes, my lord. Wife is also residing in Calcutta. Only to harass myself, my petitioner is.
So you have given the address at Andaman.
Andaman, my lord, that is the wife's address, wife's parental address, my lord, parental house address. But right now, but my lord, kindly see my body, my lord. I am
Transfer of application under section 125 CLPC can be done at the instance of the wife.
yes, my lord, at the instance of wife, but why where the parties, my lord, live together at the jurisdiction, my lord.
Issue notice upon the respondent. This is the matter in the available.
Highly obliged, my lord. Highly obliged.
Stay.
Highly obliged, my lord.
Petitioner, my lord, a very raucous and small player before my lord. I filed a petition. This is a case of POXO which is pending for trial before the special judge POXO, my lord, wherein charge sheet was filed. I was granted bail. Charge sheet was filed. In the charge sheet, there are 24 listed witnesses, Your Honor, my lord. And accordingly, when the matter was fixed for evidence, I filed a petition under section 254 subclause T of the BNSS for examining the victim, mother, and the maternal aunt, who is the de facto complainant, on a single day. The same was turned down by the trial court.
So is it possible for the court
My lord,
Your right cannot override the convenience of the court.
my lord, may kindly appreciate.
In one day, victim shall be examined, her mother shall be examined, her maternal uncle shall be.
My lord, the reason behind is, my lord, these
Yes.
are the only three important witnesses as far as the case is related. And suppose if, for example, my lord, if I cross-examine the victim in a day, my defense will be disclosed.
You can defer your process.
That is what I played before the court below, that all the three witnesses examination in chief may be recorded in a day. I'll cross all the witnesses on the same day. That was my prayer, my lord, and 254 subclause 3 says that.
Yes.
So I pray before the court below, but the court has turned down.
What is
My
the
request,
What are the grounds for rejection?
my lord may kindly come to page number 38, my lord, of my document. This is the order of the court below.
38.
38, my lord, last page.
Yes.
It starts from 37, my lord, bottom. May I request, my lord, to kindly come to 37. Therefore, in a POXO case, when the victim deposed certain safeguard as provided to the VG at the time of the deposition, and the same are normally taken in the presence of family members, guardian, a friend or relative, in whom the child has trust or confidence, be present in the court. As such, this court is of the opinion that the instant application is misconceived one, and it will result in defeating the purport of the statute and result in dragging and delaying the litigation by not maintaining the timeless inclusion of the trial. I'll pause this honorable court for a moment. My intention was very clear, my lord. I want to expedite the issue so that these three important witnesses can be examined in chief on the same day. On the next day, it may be fixed for my cross-examination.
I cannot ask.
My lord,
Deferment of cross-examination can be done.
my lord, but kindly appreciate one.
If there is any resolution of the bar on that day, what would happen?
My lord, I can understand if the situation arose as such, but my lord may kindly come to once.
In one day, I shall direct I shall not.
This happened, my lord.
I can ask me to defer the cross-examination until other witnesses.
My lord, that will do, my lord.
Where you have made, where is your petition?
My lord may kindly come to my petition, which is at page number 15, my lord.
Page number 15.
Of the documents.
15. Yes.
My lord may kindly see, my lord, page number 16 is the petition.
The handwritten petition.
My lord.
Yes, please read.
The matter is fixed today for evidence that the accused person is charged under section 3B, 4, 5L, 5M, 5I, 5N, 6 of POXO Act 2019, that with section 376, 323, 506 of Indian Penal Code. That the counsel for the accused person intends to examine CSW 1, de facto complainant, CSW 2, seizure witness, and CSW 3, victim girl, on the same day. As such, the counsel prayed to call upon all the three witnesses on the same day. The counsel has filed the said application under section 231 subclause 2 of CRPC, section 254 subclause 3 of BNSS 2023 to examine the above mentioned three witnesses CSW 1, CSW 2, and CSW 3 on the same day. That now prejudice will be caused if your honor may allow the said application, petition, and pass necessary order as this honorable court may deem fit.
Yes.
And then my prayer, my lord.
Yes, and what is said? Yes, please.
On that day, victim was present.
Victim was present.
Victim was present.
No,
Without examination, the victim, matter was adjourned, next date is fixed for examination of the victim.
yes.
On that day, the petition has been filed by the.
So why you cancel the bail and take him into custody? Okay, I am giving that direction.
My lord, but kindly,
You can defer,
My
but
lord.
on the same day you have to produce three
My lord,
witnesses.
I would-
It is not possible.
I would request before my lord, if that order is passed, my lord, my intention is very clear, my lord. I don't want to delay. Let there be a direction upon me. I'll do it on the same day, my lord. I'm not seeking
I
any
am not
adjournment.
going to give that on the same day. You have to examine three witnesses.
In that, my submission before the court below was very simple, my lord, and very candid and simple, that let the chief of three witnesses may examine on the same day or as per the routine. I will cross-examine all the witnesses together because my defense will be disclosed. I am 68 years of age. We are residing in a barrack, my lord. And till date, there is no NB challan against me. I am a retired man.
So whatever it may be, the oratory or the skill of the cross-examination of the lauded counsel is the most vital thing.
My lord, that is why I requested the court below, because if I cross-examine.
You have been on bail. That's why you are taking.
No, my lord.
I'm asking to cancel the bail. Or
my lord may kindly appreciate on the day when I filed my wakalatnama, I paid for this.
Why you have taken this plea? You can persuade the court that I shall not cross-examine the victim unless the other two witnesses are examined.
My lord, I will pay that order may pass, my lord. I will not stand in the way, my lord.
But not on the same day.
My lord,
It is
my
not
lord,
possible.
my lord, my lord.
Okay, the learned counsel for the petitioner has submitted that he wants to, the learned counsel of the petitioner in the trial court wants to cross-examine the victim, victim's mother and victim's maternal uncle,
Auntie, the de facto
Auntie,
complaint, my lord.
auntie,
De facto
auntie,
complaint.
aunt on the same day, and for otherwise there is chance of disclosure of his defense. Stop. For the purpose of persuading the learned special judge under POCSO Act, he had made an application in that regard on
4/4/2025, my lord.
2025, but the said prayer has been rejected by the learned special judge, and against such rejection order dated
4/4/2025, my lord.
4/4/2025, the present revisional application has been filed. Stop. Para. The learned counsel for the state opposes the prayer as made out in the said revisional application. According to him, on 4/4/2025, the victim girl was present, but she was released by the court as the present petitioner filed the said application, filed the application praying for allowing him to cross-examine all the three witnesses, namely victim girl, her mother and her aunt on the same day. Stop. Para. I have considered the materials on record. It is true that the accused has some legal right to defer cross-examination of some witnesses if he feels that there is a chance of disclosure of his defense. But the prayer of the accused, of the petitioner, the court should ask all the three witnesses for examination on one day, and thereafter he will cross-examine all the three witnesses on this said date, cannot be allowed since the learned special judge has to deal with many other cases. However, for the sake of convenience, the learned special judge should consider that the petitioner should be given a chance to cross-examine all the said witnesses one after another, one after another, or cross-examine one after another, until the examination of other witnesses. In other words, I want to say that deferment of cross-examination of 3 witnesses can may be granted for a limited period so that the defense of the petitioner cannot be jeopardized. In view of this same, I direct I have directly বলেছি সামনে। I therefore direct the learned special judge to consider the prayer for deferment of cross-examination of victim girl and her mother and her aunt may be deferred for a limited period for the sake of justice. Stop. With this direction, the instant revisional application is disposed of. Any other thing, Mr.
My lord, I have filed a CRAN application. I may be given liberty to withdraw the same. There was a CRAN for stay in the same petition. Stay, my lord. Since it has been disposed of the main petition, I crave leave to withdraw the CRAN.
First এটা লিখে দিল। The learned counsel for the petitioner seeks leave to withdraw the CAN application number such and such.
1 of 2025.
His prayer is he said CAN is disposed of as dismissed as withdrawn. Dismissed as withdrawn. তারপরে এটা লিখে দেবে, ঠিক আছে? Okay.
Without taking further adjournment.
হ্যাঁ, without taking further action, last line. Without taking any further action. That's all.
Good.
Lordship, I am for the state lordship.
I am for the
It's a criminal appeal lordship
respondent accused.
against acquittal.
Yes.
Under Prevention of Corruption Act.
Yes.
Two CRAN is pending. One is section 5, 520 days delayed is there. And one is a special leave to appeal. That is mandatory under 378. That is pending. Preparation. I already filed affidavit of
Certificate has been given.
lordship.
Any certificate is required for from the PP or something like that.
Lordship, some sanction.
Sanction.
Proper approval is there from the authority concerned for filing the appeal against.
So leave should be granted.
My lord, I have got objection because there is 600 days delay.
So,
If they 520 days delay, if they pray for leave, my lord, then argument may be taken up for the leave. I am ready for giving the
Argument.
reply, my lord.
Have
Giving
you submitted
reply,
written opposition?
my lord.
Have you submitted?
No, it was received to me. It was received to me yesterday only the night.
The learned counsel for the state has submitted that this appeal has been filed against the order of acquittal. Stop. There is a delay of how many days?
520 days.
520 days. And leave may be granted. And also a petition seeking leave to file the present application, present appeal. Stop. Para, the learned counsel for the
Respondent,
accused.
my lord. Respondent, my lord. It's a case of
Respondent, sorry.
acquittal.
Respondent has submitted that he wants to contest the above application for condonation of delay, and for that purpose he wants to submit written opposition. Stop. The respondent is at liberty to file written opposition within 3 weeks from date. Affidavit in reply. Affidavit in reply, if any, be filed within a week thereafter. This is the matter before.
My lord.
Blair.
भाई limitation का petition देगा दिया नहीं
Yes, sir.
नहीं दिया
Yes, sir. 10 is not here, not today. Ten is not, anybody is, is not well. What happened? Not today.
The Lordship, for item number 11 and 12, I pray for a short pass over there.
I'm for opposite part.
11 and 12, he said. 11 and 12.
In the MSCT case, was lots of
11 or 12. He seeks for, she seeks for
Short
a
Passover
Passover.
for 11 and.
Passover. Huh? So you are not ready?
I have,
Not today. Okay, not today. 11 and 12, both.
No, only 12.
Oh, 12, not today. Okay, 11,
Request one thing, my lord.
Passover. 11 is Passover.
Tomorrow, can be disposed of because these are matter very, other matters are pending before the.
So I am ready, but what can be done? Your brothers
On the
and
top of
sisters.
this tomorrow, my lord, as it is the last
Okay,
day.
okay. Last 2 or 3 matters, no problem.
My lord, no.
Not today, not today.
11.
Now 11 is Passover.
Passover.
Passover, yes. Yes. 13.
Your Lordship, for the petition of Your Lordship. Your Lordship, I have gone through the opposition.
Yes.
We will have to file a reply because they have raised a point of maintainability. On the ground, there is a alternative remedy. But Your Lordship, my submissions will be twofold. I will be pressing for an interim order, Your Lordship. And I'll also be before Your Lordship, the interim order, I have to also satisfy that this reparation is maintainable and also entertainable, Your Lordship, in light of a Supreme Court judgment and the facts, Your Lordship. Your Lordship, if kindly.
So interim order, are you enjoying interim order?
No, Your Lordship. It was, Your Lordship, the interim order on the last occasion.
What is your prayer?
My prayer is, Your Lordship, I had gotten license for the C area. This is the only.
No, have you made any prayer for?
Yes, I have made. Your Lordship, on the first occasion that the matter was taken up by the Honorable Coordinate Bench, the Honorable Coordinate Bench at that point of time refused and specified that at this stage, it is in bold, Your Lordship will see the order, the first order. At this stage, I am refusing because at that point of time, there was no direction on the other side. Now, Your Lordship, if I may be able to just place the case, I will hardly take 5 to 10 minutes, Your Lordship. I will not take much of Your Lordship's time.
And there is another person.
Your Lordship, they are proper parties, Your Lordship, not necessary parties because they represent the port management board who have given us the license for the sea area. They have already given us the license. I will be going through that order also.
C area license.
Sea area license I have gotten.
Land area.
Land area they have rejected. On a ground, on a point of law, Your Lordship, they have rejected. They are saying that we can challenge that under regulation 28 because it's an appealable order. I will be countering that also that in spite of that, this reiteration is entertainable on account both of the fact that a question of law is involved, a Supreme Court judgment, recent judgment, Your Lordship, specifies that, and on account of their opposition, particular statements in their opposition, which shows that even the appellate authority, Your Lordship, they have affirmed this, the appellate authority as per regulation 28, they have also affirmed this opposition, basically giving the same reason that the 2013 policy, because of the 2013 policy, I am not entitled to it. If I may then able to, Your Lordship, please. First, Your Lordship, I am specifying that I will be rebutting the maintainable point. Let me place my case, Your Lordship.
If there is an appeal problem.
Appeal?
if there is an appeal provision that is in section 28 of the LR and LR Act. So once there is an appeal provision, there is an alternate remedy. Now there is a division bench judgment of this court, where it says that when there is an alternate remedy, when the party has to first approach that alternate remedy.
Your lordship, I have to rebut that also. I am trying to
And there
rebut
are
that.
other judicial decisions also.
No, those.
Let me, your lordship.
That division bench is that.
Even in the subject matter, they have prepared an appeal, second appeal, in the subject matter also.
Second appeal.
What is that?
No, your lordship, let me have this place.
He did not avail of that alternative remedy.
Previous round of litigation.
That has no bearing here, your lordship.
Litigation, they have challenged the order of deputy commissioner before the secretary revenue.
Yes.
And after the passing of the order of the secretary revenue, they have challenged this before this.
Your lordship, we did not just carry.
Can you appoint the page number 26?
Okay, I said.
Your lordship, if I may be first allowed, if I'll keep it brief. I'll keep it very brief because I'm pressing for the entry model.
Just,
Your lordship, the land area, my laboratory is there. I may be allowed to work in the meantime that I file my opposition because they, by their actions, they have delayed. They had gotten the chance to file the opposition long back. They did not. We had given in the meantime also. We had placed that letter before your lordship. They kindly file the opposition so that we can file the reply. And this matter could be run and decided in this circuit bench only because for 1 month they'll want. I am enjoying the C area license. I am paying license fees for that, which my learned friend is appearing for the same.
They are not disturbing him.
Yes, but my livelihood, that is my only source of livelihood. This is the only saltwater marine culture project in India, your lordship. I have received the permission for that. Because of this, my work here. And they are not utilizing anything. It's not that they are utilizing the land for anything also. So in that, if your lordship kindly just looks, even that is that I have, your lordship, I am not being allowed to submit, your lordship. I will be going through the division bench's orders also, your lordship.
What is your prayer? I want to see.
My prayer is to set aside the order, impugned order, whereby it was rejected. My prayer, my application for license of the land area, it was rejected. I am seeking set aside of that on the ground that the 2013.
Why you have not taken alternative?
I am coming to that. I am coming to that, your lordship, if I may.
Yes, so was the order. And the alternative remedy.
Alternative provision will also show your lordship, and I will also rely upon the opposition, your lordship. But firstly, your lordship, kindly just, if I may be allowed, at page 56, the honorable division bench's order regarding.
Why is the rejection order? You have
Rejection order, your lordship. Impugned order is at.
According to them, you have the alternative remedy, you should go there, according to them.
Yes, your
Now you show us that rejection order.
rejection order, your lordship, is at order for page 84, your lordship, it starts.
84.
84, your
In the
lordship.
court of the Deputy Commissioner, South Andaman.
Yes, your lordship.
This is the rejection order.
Yes,
Wait,
this is the impugned order.
Impugned order, your lordship.
So you are the party.
Yes, your lordship.
You are the party.
He is my assistant.
Yes.
Your lordship, kindly sees, I am not going into the majority of the thing. They have specified, your lordship, at fourth paragraph, whereas they have specified about the previous case, whereas the director of Pearl Meritic Private Limited was initially granted a license for land at North Bay in exchange for land they surrendered at Collinport. This land was allotted for pearl culture under RC number such and such. However, the company failed to use the land for its intended purpose. Consequently, the license was cancelled by the Deputy Commissioner and the land was resumed under Section 151C and Section 162 of the Andaman and Nicobar Islands Revenue and Land Reforms Regulation. Whereas
You have given a land.
I was not given the land, the company was. That is why, your lordship, I wanted to place the division bench's order, which had decided the issue. The division bench has specifically said that my credentials are not called into question. I can apply again for fresh license and that will be decided independently. I had on the 8th, your lordship, when I was, your lordship, I was allowed to move before your lordship, I had placed that order also at page 56. Thereafter, your lordship, whereas Dr. Ajay Sonkar submitted a representation on 9/5/2024 requesting the renewal of reallotment of land adjacent to serial number such and such at North Bay for the purpose of pearl culture and research. Due to the lack of action on this representation, he filed the writ petition to expedite this disposal of his application. Whereas during the hearings, the petitioner was represented by Advocate Manas Ajay Sonkar. Whereas this is the reason given for rejection. These are just the facts that have been recorded, Your Lordship, previous facts. Whereas the Deputy Commissioner considered the provisions of the Andaman and Nicobar Islands land allotment policy of 2013, which specifies that government land can only be allotted to government departments, central government agencies, defense and government funded corporations or society. Whereas the petitioner, next page, Your Lordship, is an individual and not part of the eligible categories under the policy, his request for land allotment could not be considered. This was the reason. Now, my proposition, my contention before this is this particular policy, this is with regards to only government entities. This policy does not, the object of this policy is not with regards to private entities or private companies. The regulations in 146, subclause 2, Your Lordship, the commissioner has the power to grant license, which I was allowed to grant license. So it is a pure point of law I want to argue on. Now, Your Lordship kindly takes their opposition once. They wanted to specify that why I am not going before the Chief Commissioner, who is the appellate authority. Your Lordship, opposition, Your Lordship will see who has affirmed, for whom the opposition has been filed. And Your Lordship kindly also takes the writ petition side.
You are not controverting all these things. You did not file any affidavit in reply. That's why.
No, Your Lordship, I am praying. How will I, Your Lordship, they have given it yesterday. I will place that. At this stage, Your Lordship, I am just praying for an interim order, Your Lordship. I find maybe, Your Lordship, they are not allowing me to submit. Your Lordship, Your Lordship, can you allow me to submit?
That whether you did not file any.
How will I, Your Lordship? Last day only they gave us, it is recorded in Your Lordship's order. Your Lordship kindly sees affidavit in opposition filed on behalf. First page itself, Your Lordship. They have said affidavit in opposition filed on behalf of the respondent number 2, 3. 3 is the appellate authority. They are saying that I am the respondent number 8 in the above case, and I have been served with a copy of writ petition. I have understood the purport and contents thereof, and I have been duly authorized and competent to affirm this affidavit on behalf of the respondents number 2, 3, 4, 6, and 7. 3 is the appellate authority as per Rule 28. What does the appellate authority affirm? It affirms, Your Lordship, at page 10, last paragraph of page 10. Kindly seize, Your Lordship. The ground for rejection of the it is further submitted there is no scheme in vogue as per the Andaman and Nicobar Island policy of 2013. That government land can only be allotted to government departments, central government agencies, defense and government funded corporations or societies. So they have already decided, the appellate authority, that I am not entitled to the license. Now, Your Lordship, I am relying upon this judgment of the Supreme Court, this 2023 SCC online SC 95 by the division bench. Your Lordship, kindly, I'll just go through, Your Lordship, paragraph 4 and 8, just paragraph 4 and 8. And then I will come back to the facts, Your Lordship. Because in light of this, if Your Lordship has gotten the judgment, paragraph 4, Your Lordship, kindly takes up paragraph 4. Your Lordship, I'm starting, Your Lordship, if I may be allowed. Before answering the questions, we feel the urge to say, a few words on the exercise of writ powers conferred by the Article 226 of the Constitution, having come across certain orders passed by the High Courts holding writ petitions as not maintainable merely because alternative remedy provided by the relevant statutes has not been pursued by the parties desirous of invocation of the writ jurisdiction. The power to issue prerogative writs under Article 226 is plenary in nature. Any limitation on the exercise of power must be traceable in the Constitution itself. Profitable reference in this regard may be made to Article 329 and ordinaments of the other similarly worded articles in the Constitution. Article 226 does not, in terms, impose any limitation or restraint on the exercise of the powers to issue writs. While it is true that exercise of writ powers, despite availability of a remedy under the very statute which has been invoked and has given to the action impugned in the writ petition, ought not to be made in a routine manner. Yet, the mere fact that the petitioner before the High Court in a given case has not pursued the alternate remedy available to him, it cannot mechanically be construed as a ground for its dismissal. It is axiomatic that the High Courts, bearing in mind the facts of each particular case, have a discretion whether to entertain a writ petition or not. One of the self-imposed restrictions on the exercise of power under Article 226 that has evolved through judicial precedents where an effective and efficient alternative remedy is available At the same time, it must be remembered that the mere availability of an alternative remedy of appeal or revision, which the party, availability of an alternative remedy of appeal or revision, your lordship, which the party invoking the jurisdiction of the High Court under 220, Article 226 has not pursued, would not out the jurisdiction of the High Court, and a render or writ petition not maintainable. In a long line of decisions, this court has made it clear that the availability of an alternative remedy does not operate as an absolute bar to the maintainability of the writ petition, and that the rule which requires a party to pursue the alternative remedy provided by the statute is a rule of policy, convenience, and discretion rather than a rule of law. Though elementally it needs to be restated that entertainability and maintainability of writ petition are distinct concepts, the fine but real distinction between the two is not to be lost sight of. The objection as to maintainability goes to the root of the matter, and if such objection were found to be of substance, the court would be rendered incapable of even receiving the list for adjudication. On the other hand, the question of entertainability is entirely within the realm of discretion of the High Courts. Writ remedy being discretionary, a writ petition being maintainable may not be entertained by a High Court for very many reasons or relief, could even be refused to the petitioner, despite setting up a sound legal point. If the grant of claim relief would not further public interest, hence dismissal of a writ petition by a High Court on the ground that the petitioner has not availed alternative remedy, without however examining whether an exceptional case has been made out for such entertainment, would not be proper. And your lordship kindly takes up paragraph 8 thereafter.
Yes.
That apart, we may also usually refer to the decisions of this court reported in the lordship. Certain citations have been given. What appears on a plain reading of the former decision is that whether a certain item falls within an entry in the sales tax statute raises a pure question of law. And if investigation into facts is unnecessary, the High Court could entertain a writ petition in its discretion, even though alternative remedy was not availed of. There was an remedy of appeal in the Income Tax Act, your lordship. It was not availed of. They came before the High Court. It was rejected. They came before the Supreme Court. And if investigation into facts is unnecessary, the High Court could entertain a writ petition in its discretion, even though alternative remedy was not availed of. And unless exercise of discretion is shown to be unreasonable or perverse, this court would not interfere. In the later decision, this court found the issue raised by the appellant to be pristinely legal, requiring determination by the High Court without putting the appellant to the mill statutory appeals in the hierarchy. What follows from the said decision is that where the controversy is a purely legal one and it does not involve disputed questions of fact, but only questions of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of an alternative remedy being available. Now, your lordship kindly takes up Rule 28. I have annexed that Rule 28 that they are relying upon. And then I'll just be going through the order whereby the C area license has been granted by the Chief Court Management. My learned friend is vehemently objecting to this petition, but although they have themselves granted license to me for the C area, I do not know why, but I will use the reply, your lordship. I am interim order for the interim order, your lordship.
How can without
Your lordship kindly takes up at page 185. The policy is at page 185, your lordship. No, your lordship, not the policy. The rules are at power to count slides. Regulation is 145, your lordship.
185, yes.
Yes, 185. It is at page 90, your lordship. 93, your lordship. 93.
Yes.
Kindly see is 28D. If such order is passed by a deputy commissioner, whether exercising the powers of deputy commissioner or settlement officer during the currency of the term of any settlement to the chief commissioner. So the chief commissioner is the person before whom I had to approach. The chief commissioner by their affidavit, your lordship, has specified that we cannot grant you license because of the particular policy. The particular point is of law that I am raising before your lordship. Now your lordships would see that they are saying that the company, and it was rejected. If your lordship would see the order once before that, the order at the land area at page 84. Land area at 84. If your lordship comes back to page 84 once. At page 85, it has been by the deputy commissioner. Now, in the opposition, they have specifically given the particular reason. Now, your lordship, by their opposition, at page 56, your lordship, takes up the division bench's order, your lordship, which they are specifying the company had come. At page 56. Page 56. Para 36, your lordship. Having considered Mr. Bhattacharya's submission, this bench holds that this order is limited to the correctness of the findings of the learned single judge in the writ petition with regard to the cancellation of license and resumption of the land which was allotted to the appellant number 1 company, the company that they speak of which Dr. Sonkar is no more a part. He is only concerned about the order affecting his reputation and position. This order is not a declaration on the personal achievements or failure of Dr. Sonkar. Dr. Sonkar's right to continue with any pearl culture activity under the administration or under any other authority have not been decided in these proceedings. So my ability, my faults or nothing was decided. That is with regard to the company. So because of which I made the...
You are not a part of that company, right?
I am not a part. During that, I was an intervener in this. I was not part. That was I was not allowed to be a part. I was not made a party to this. I intervened in this. And because I was working as per a sub license, I was working in that line.
License cannot be granted. I want to know from it. License cannot be granted to any individual or something like that.
Yes, that is I'm coming to also. So, they are saying their policy, your lordship, it can be granted. That is the whole point.
Yes, whole point.
It can be granted. The policy is an administrative. If I may be allowed, your lordship, I'll take your lordship to the policy then.
Too much time. I have no problem.
Your lordship,
you have already consumed 10 minutes. You have said 5 minutes. You have already consumed 10 minutes.
Your lordship, I'm not exactly timing myself. Well, if your lordship kindly sees the policy once, kindly just sees the policy once. Page 173. 173.
You are an individual. You are not a part of the company. So 173.
Page 173.
173.
At page 1, the policy starts as 173. 177, your lordship, is the background.
177.
177 is the background.
Yes.
There is no comprehensive land allotment policy for the ANI administration, and the approach so far has been based on case-by-case basis, based on the individual proposals for allotment of land by the user agencies. This approach has often resulted in allotment of land in excess that what is required in place where the land is one of the scarcest resources accessed with the administration. Also, it needs to be mentioned that the user agencies which has got the land allotted in their name could not maintain it properly and with due diligence, resulting in creeping encroachment, which has alienated the land from the agency to which they are originally allotted for a definite public purpose. Your lordship will see in order to the following issues multiple requests. Point 1, multiple department and agencies are requisitioning for the allotment of land for development purposes. Industries, energy, IT, tourism, housing, defense, and for social purposes. Then your lordship will see at 180.
According to the written affidavit in opposition, the policy, the present policy does not approve.
Approve of, yes,
policy granting of license to any individual. That is the sum and substance.
And your lordship, if I may.
That has not been challenged by filing an affidavit in reply. How can I agree?
No. I am asking for an interim because there's a reason. If I may be allowed to answer your lordship, kindly sees 180. Request by concerned department, organizations, institutions. Page 180, the first line, request by concerned department, organization, institutions. And page 182, your lordship. The objectives. The first objective.
Your verbal submission is not.
Your lordship, I'm praying for an interim.
No, you have to come with the affidavit in reply by tomorrow. I shall consider. No problem.
Your lordship, it will not be possible to ready an affidavit in reply. And
you also, please, you also consider my difficulty. Okay.
Then your lordship.
I have given sufficient time to you, not only for this day.
Your
On
lordship,
that day, he was
sufficient,
not ready.
sufficient time was given to them, your lordship, not to us. We were received
Certainly,
yesterday,
certainly.
your lordship.
But
One,
last day is
just your lordship, one thing, page 182, 180 is there and 182, your lordship, to ensure, 182, your lordship.
yes, 182 to ensure
We have optimal and judicious utilization of scan resources in land Nicobar by satisfying development needs of various agencies, namely departments under the Andaman and Nicobar Administration, Defence Society, Charitable Trust. And your lordship, page 185, land allotment for government agencies and eligible societies.
yes.
Land allotment for government agencies and eligible society 1, 2, 3, 4 till 7. All of them are departments, central government departments, defense, undertaking, corporations, companies controlled and managed by the central government. So not a private entity. But your lordship, if your lordship will see the regulations, parent regulation, the act of parliament, your lordship, an administrative policy cannot circumvent the powers of an officer or of a act of parliament, your lordship. This regulation is an act of parliament. It is a settled principle, your lordship, cannot be so. At page, your lordship, at page 146, your lordship will find at page 140. At 115 is the specific part, but it starts 146 at 114.
Yes, 146.
146. Chief Commissioner may on such terms and to such conditions as he thinks fit at the last, your lordship, 146, the last regulation.
Yes.
The Chief Commissioner may on such terms and subject to such conditions he thinks fit. The first one is not important. The second one, your lordship.
146, there is no such
Page 114, your lordship.
114.
114. Section regulation 146, your lordship.
114. Yes. 140. The Chief
146. The Chief Commissioner may on such terms and subject to such conditions as he thinks fit. The next part, your lordship, the subclause 2, I am relying upon. This is with regards to cultivation and land and all. I am not seeking with regards to cultivation of land. 115, your lordship, in the next page.
Make to any person for the cultivation of coconut,
Yes.
coffee,
And if your lordship,
rubber, peace leaves, and other long-lived crops for the constructions of building to be used for the kind of land for is not part of
next page, your lordship, this subclause 2. Subclause 2.
Subclause 2.
Under subclause 2, grant a license
Grant a license
in writing to any person to occupy any land to such extent and for such purposes as may be prescribed.
Yes.
And promoting of marine culture as per the 7-year plan, your lordship, is very important. I have annexed that also. I'm not going into that right now because
There is
I am,
no such. Asun.
your lordship, if I may,
The learned counsel for the
your lordship, sea area license, your lordship, the sea area license.
submitted that the petitioner has been granted license in respect of sea area,
Sea area, your lordship.
sea area pulp
Yes, sir.
for experimentation on
For research and pearl culture, sustainable pearl culture, saltwater marine pearl culture, your lordship.
for carrying on pearl culture on
Saltwater marine pearls.
saltwater marine pearls. But he has not given the license in respect of land area. Same. Salt marine pearl culture. Right?
Yes, your lordship. Sustainable marine culture of saltwater pearls. Sustainable
marine
culture of saltwater pearls.
saltwater pearls. Okay. Stop. The learned counsel has sought for an interim order until the hearing of the petition is concluded. Stop. The learned counsel for the respondent numbers 2, 3, 4, 6, 7, and 8 has raised objection. According to him,
No scope and
there is no scope. There is no scope for the petitioner to have an interim order since the present land allotment policy does not permit an individual to obtain the relevant license. Stop.
Well, there is also no prayer in this regard.
Stop.
Land is not required, because it has to be cultural and sea.
I am not seeking setting aside of the policy. I am saying that the policy
Yeah.
is with regards to how land will be given to other departments, not with regards to
Sure.
private individuals or private companies.
It appears that the affidavit in opposition filed by the
They cannot say that they have never
By
given
the-
it to
by the-
private
by the-
individuals
by
post
the-
2013.
by the respondent numbers 2, 3, 4, 6, 7, and 8 has specifically mentioned that the land allotment policy does not permit the petitioner to does not permit the petitioner to have a license in respect of land area.
In respect of Malad,
Land is not required for culture purpose.
Land area
This requires-
does not permit the petitioner being an individual to
for land allotment.
experiment land pulp culture in land area, as
And the petition is not maintainable alternate.
Stop.
Project has already been running since.
Stop. Correct.
On the same land level.
Your Lordship,
From the
even-
record, it is transferred that by order dated 56,
56, Your Lordship.
by order dated 56,
This order is, Your Lordship, dated.
Justice Sampos order,
Sampad Sarkar, Your Lordship, April 12, 2024,
April 2024,
at page 36, Your Lordship.
it has been held by a coordinated, it is held by a division bench of this court that petitioner is not,
Your Lordship, till this.
is no more a part of the appellant company. Is it correct? Appellant company. Stop. However, the petitioner is at liberty to file any affidavit in reply if any, within 2 weeks from date. List the matter before the next
Your
available.
Lordship, one prayer, Your Lordship, liberty to mention before the principal bench.
Liberty to mention.
Why not, Your Lordship? They have this. Your Lordship, my sole source of livelihood from April 12, Your Lordship, after, Your Lordship, if I may be allowed.
Allow him to.
I'm not allowed to speak. It's not that I'm accepting. I will speak. At least. Your Lordship, April 12, 2024, after the division bench's judgment, I have been not working there because the order has been.
Even if I give you liberty, you can
Your Lordship kindly gives the liberty.
No. I cannot say so because
Your Lordship, they are dragging this proceedings, Your Lordship. 2 months there is
Mr. Bhattacharya, I do not know what is your name.
Shayan Chakrabarty, Your Lordship.
Chattopadhyay. Mr. Chattopadhyay, I have asked them to file affidavit in opposition. They have filed.
Your Lordship sees when the order was, Your Lordship kindly sees
You
this.
just must be grateful to the court.
Yes.
Yes, definitely, Your Lordship. I am grateful to the court. I am very much grateful to the court. That is why I am pressing this before this court, Your Lordship. Kindly sees this, Your Lordship. I have given them a letter previous to before this, after the first order was passed. They kindly find the opposition.
They initially first day they sought for a 2 weeks time,
Yes, Your Lordship.
and
Your Lordship asked me also to come
that is
before Your
your
Lordship.
achievement. That is your achievement so far as this circuit bench is concerned. Okay,
One
next.
thing, Maintenance point may be kept open.
It is kept open. It's a question of.
Open. It has been open.
It is anyways kept open because the
problem.
direction was given.
It can be taken out at any point of time, and so far as the present is. Next. Okay. Well, nobody is here. Not today. আর নেই তো দেখো ডাকুন 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 তাড়াতাড়ি ডাকুন
They have not filed the opposition yet, you know. Apparently direction should be given to them.
the respondent should the learned counsel for the petitioner has submitted that the respondent did not file any affidavit in opposition. Stop. But when this case was filed,
In the last notification.
how can this? But nobody is here.
That is problem, you know, why they have appeared before this honorable court on the last petition.
Now,
And today nobody is appearing.
nobody is nobody has appeared on behalf of the respondent. List the matter in the next available circuit. কিছু করার নেই। Okay. আর কি আছে?
Yes, on the opposite banks for condemnation of the election. My most important point is that election, they kindly note that they are objecting with regard to the condemnation of the. Whether they have made any payment to Calcutta, what has been directed by the learned tribunal, even that has not been paid till today. I can understand your.
What is the deal? How long?
2 years, your worship.
It's 2 years.
Yes, because the claimant, the reason is that, your worship, the claimant is practically an uneducated lady, your worship.
The lady, you understand, you must have some feelings for the ladies. 2 years, why? Is it
Actually, what happened, your worship?
illiterate?
These matters, your worship knows that once the claimant is examined, thereafter, your worship, generally what happens, the claimant, they used to do their own work and there will be other things, your worship. Now, so what happened, your worship, she has told me that whenever the award is passed, I have to contact her and inform her. She has given a number to me also.
And now you are now blaming an advocate.
Worship, I am saying.
What can we
Blaming
now?
myself.
There is.
Not any other advocate. Blaming myself. I tried my best to contact her, the phone number which has been given to me, but could not contact. That is the reason why delayed happened. And here, just 1 minute, your worship.
860 days.
860 days.
So more than 2 years.
Your worship. There is a decision of this honorable court, latest decision, your worship. There similar days was allowed, your worship. There was some confusion between the. This is of 5th March to 2024. This honorable court, Milinda Mazumdar versus Dilip Kumar Barwa. There, your worship, same thing happened, 812 days delay was there.
No, that is different thing. I do not know, but you have to explain why.
I explained, your worship. This is what I
Explanation is necessary.
Yeah.
No, otherwise anybody can come after 4 years
Explanation I have given, your worship.
and there is a judicial decisions of Honorable Supreme Court is also. Explanation must be there.
I've in detail,
Yes,
I have
yes.
explained. Your worship, I kindly see here. Paragraph 4, that when the impugned award was passed, the council tried to inform the claimant about the impugned award by calling her in the phone number provided by her, but the same could not be corrected. And only in the beginning of June 2024, the council was able to contact claimant as one of her relatives had come for a consultation for another case, and during such conference, the council came to know about the contact details of the claimant. That is the council hearing, and when she has explained about the non-inclusion of certain composition criteria in the award, she conveyed a decision to challenge the award before this honorable hearing. That given, I've mentioned it.
Hey, why is,
Not mentioned.
hey, why is the section 5? Yeah, yes, got it.
And the idea version.
So your compensation has been awarded. How much? How much?
3,39,000.
The death case?
Death.
Oh. So you want to enhance?
I do. Because as per the decision of the Honorable Supreme Court, Your Lordship, that after the amendment of 163A,
What was,
Honorable Supreme Court has said, in all the cases, it has got retrospective effect. Whatever has been decided, Your Lordship, 5 lakh compensation has to be awarded, at least. In that cases, 5 lakh.
hmm.
That is the standard compensation. Your Lordship, even if I am submitting, Your Lordship, even if this particular amount along with the interest what has been awarded by the court, if they are coming with that, I think my client will agree for that. And the matter can be finished.
I cannot
Because they
say.
are doing nothing, Your Lordship, they're not paying the amount. They have not taken any steps to pay the amount before the learned tribunal. At least that could have been done.
Yes, tell me, why you are raising objection?
I believe that, my lord, the negligence is only part of the claim and at the initial stage because she herself was not, she does not want to know where she lost her interest in getting the judgment. It was, she was supposed to go to the council and she needs to consult, but that was a negligence where she failed to provide her own exercise, her own due diligence of law. And secondly, and which she has been claiming for, and I would like to submit that when an appeal is preferred after the expiry of the limitation, Your Honor, then it is barred by the limitation law and is likely to be dismissed. Just merely filing for condonation of delay and accepting it, not just because that the claimant has already received an award in the court below. So that should not be considered. And secondly, if I may, I would like to say when the remedy or the right which has been not availed from a long period of time, then it seems to be valid. The power is
Barred by limitation.
barred by limitation and
Time barred,
time
according to you. Yes.
Statutory period has been lapsed for the date of filing of appeal, Your Honor, for my lord.
So you have come before a court. You have come before a court. So you are not restricting a order of another court. Why I shall allow your submission or submission of your client. No, allow junior counsel. Learned counsel. Yes, still.
Yes.
My lord, this said matter was also referred in Lok Adalat, National Lok Adalat, where my opposite party was ready to pay the amount of 3,39,000.
Just consider you are my officer, Miss Suprita Sharma. Suprit Sharma. You just look the death of a child, of a mother.
Yes, my lord,
Yeah.
I
She has lost everything.
my lord,
Only mere 3 lakhs, maybe 5 lakhs.
The awarded.
You try. You please try.
my lord,
Do some social work.
my lord, may I submit my lord?
Yes.
Opposite party is not having any source of income. And
Come
secondly,
to know. Yes, he is a very rich person.
may I submit? My opposite party does not have any source of income.
Who is opposite party here? Here opposite party is?
I'm representing
Owner of
the
the bus.
opposite, owner of the bus. And the said bus.
Oh, owner of the bus. So it is not an insurance company.
No, my lord.
So so why you have not insured?
The said bus was not insured.
Why?
The bus was burned by the public.
No, that is after the
Effects of the
incident. That is different issue. Why you have not availed the benefit of insurance?
During
You have to.
time of incident, the insurance was expired. Your Honor.
No, the life of another person is
At stake, I
Then-
accept my lord, but the point is, I'm ready for the payment of 3,39,000 which has been awarded.
No. With interest, madam. Look into
with
that.
interest.
With 9% interest, if you're ready to give,
So,
I will be ready to take it.
otherwise, I have to because you are not at all.
My lord, I would like
Entertain.
to place judgment because today it is a hearing which has been paid for section 5 for the condonation of delays to merit of the case cannot be.
No, yes, certainly.
So,
Certainly.
I would like to place a judgment where it has been clearly stated, as per the section 5, sufficient cause has not been stated in this application. And secondly, the delay is also not being specified. It is us we need to calculate the days because they are stating 2 years, 3 months, and 6 days. So we are, and it is clearly stated as per the law, it must be, days must be specified. So in I would like to say that the section 5 application must be dismissed and continuation of delay must not be allowed as it is not maintainable. I would
So
like
you want to file any case law? You want to file today?
Yes.
Yes, no problem.
Right.
Right.
And in this case, it has been clearly stated when sufficient cause is not been mentioned for the delay, then it is liable and appeal which has been preferred after expiry of limitation is liable to be dismissed at the initial stage. And when delay is not liable to be condoned just merely because that some person has been granted relief. And it is the same identical case where the claimants as claimed for a compensation for the enhancement after 5 to 6 years, as per in this case. So the
Okay.
same was.
In my opinion, the decision is different, the facts are different. Here you have somebody was sitting and watching the decision in some other case. And after
Fence sitter.
fence sitters. I think so, as per her statement, what I'm finding, I've not read the judgment. But I feel, your lordship, some other persons got the relief and thereafter, after 5 to 6 years, some other claimants have approached. And there is no sufficient grounds.
Yes.
Yes.
16 claimants were there, out of which it is on public policy, but 16 claimants were there, out of which 3 were during the pendency of the trial, 3 were deceased. And out of which all accepted the compensation, but this one from the 3, there were no steps were taken in the court below trial. And then at the time, and during that time, what happened? Even the legal heads of the disease were not substituted in this particular case. So they have failed to provide their own due diligence of law. So in circumstances, and later on they went for an appeal after 5 to 6 years. So in that, what happened, my lord, they clearly stated the limitation as human beings are mortal. So litigation should be litigation should not be immortal, your honor.
Okay. Anything else?
The decision, your lordship, add to the point, your lordship, I have.
So is
And this instruction, it was my fault, your lordship, I have told the claimant that when award will be passed, I will inform you. 812 days delay was there. And it has been done.
in some other case, you are saying that no blame should be.
You have to argue as per the case, your lordship. What can be
Your
done?
repeated submissions are made.
What can be done, your
So
lordship?
show it to her also so that she can answer. Justice Shubhendu Samanta. File a printout.
Yes,
Mr. Vishwas.
My lord, as per ma'am has shown me, my lord, I would say the days are also not specified. Sufficient cause are also not being stated. Claiming to strive for an injustice approach, which should not be.
Clement, last line, last
Injustice, claiming to strive to adopt injustice related approach, my lord.
injustice.
as
Because they have not clearly stated.
practically speaking, bona fide approach is not there on the part of the opposite party. They have not taken
Okay.
any attempt to dispose of the amount.
Execution.
Okay, give this printout, please. Give this printout. I shall pass order.
Yes.
Where is it? Printout, Mr. Vishwas.
Yes, yes.
Anything else?
Just within 5 minutes, I will.
Yes. Hey, anything else? এটা নিয়ে যাবো ভেতরে দিয়ে দিচ্ছি আপনি অর্ডার দিয়ে দিচ্ছি আমি ভেতরে দিয়ে দিব এখনো প্রিন্ট আউটটা দেবে তারপর তো হ্যাঁ ওকে আই শ্যাল পাস
But we still, everything is.
चलती है क्या? अरे वो तो छोड़ ही नहीं आता। अभी हियरिंग मैंने पकड़ लिया है। गलती करेगा लगता है वो शाम को कॉलेज जाकर। नहीं ना, बढ़ता है तो बढ़ नहीं। और 2 दिन से बाहर तेरा नंबर This is better on the
Okay.